Hi, this is Lisa DeMonte from mylegal.com. We're coming to you live from Washington, D.C. at the Georgetown University Law Center, the third and final day of the conference, Law Firm Evolution, Brave New World, or Business as Usual. With me this afternoon is Tony Sebock, who's a professor of law at the Cardozo Law School. And Tony just published a paper called Third-Party Litigation Funding. Tony, thank you so much for joining us this afternoon. We appreciate it.
Glad to be here.
You were part of the panel. It was a lively discussion about third-party funding. Why do you think that in the United States, at least, there's so much hostility towards the influx or the introduction or the thought of investing in litigation?
Well, it's historically rooted. The English law, which we inherited, prohibited it in extraordinarily strict ways. That's been sort of slowly changing, but the truth is there's still a stigma associated with people profiting from litigation. There's an idea that litigation is not a business, that litigation is about correcting wrongs, which is probably, of course, true, but the truth is that in the world we live in, you need money to litigate, and people do litigate often to get money for the damages they suffered so they can purchase replacement for the things they lost. So while it may not be a business in its purest form, it has a lot to do with money, and so the stigma really is just kind of an old-fashioned anachronism.
Mm-hmm. So just a change in thinking, basically, in the U.S. as opposed to what we see in the U.K.?
Well, certainly the U.K. rapidly changed, and so did Europe. I mean, the ability for third parties to invest in, say, Germany has been around for a very long time. The market isn't the Wild West market of people coming in with huge interest rates and exploiting people who are suffering. It's really a very modest, well-regulated market. The other difference that should be noted is that we had a huge change in the United States that no other country had, which might explain why we don't feel the same pressure that other countries might have felt to open up to third-party investment, and that is that only in the United States do we have the contingency fee. And the contingency fee is, in fact, a form of investment in litigation by one very particular group of people, plaintiffs' lawyers. Mm-hmm. And they're the only people who are allowed to do that.
So what do you think the benefits are for non-lawyers to be investing in litigation?
Well, the benefits range from, in smaller cases, people getting money now as opposed to waiting for a very long time, which they might have to do for their cases to settle. The benefits are larger and perhaps more structural. It might be the case that third-party investors who are not lawyers are in a better position to evaluate cases and decide which cases to invest in than lawyers. There's a lot of complaints in the last 40 years about the role of the plaintiff's bar in perhaps mismanaging the cases they have, and many of those complaints are based on the suspicion that when you're invested in a case and you're running the case, you may have a conflict of interest. Mm-hmm. Third-party investors don't run the case. Mm-hmm. They just provide the money.
And are looking at it from the business perspective,
right,
and perhaps can be a little bit more objective?
Objective, and also perhaps less tempted to cut corners.
Mm-hmm. Okay, that makes good sense. What do you think would have to change in order to allow investment in litigation in the U.S.?
Well, certainly right now investment in litigation in the form of assignment is pretty much permitted, so there's not much has to change there, although you still can't buy a claim in its entirety for personal injury. But the real opening for a market, and what you really have in Europe and in England, which we don't have here, is third-party investment partially in the claim. So you have an investment, but you don't take the claim over. And that's what's called maintenance or champerty. And for that to be effective in the United States, many things would have to change. About half the jurisdictions allow some form, but they have so many limitations that there isn't really a market developing. Investors haven't really felt comfortable or confident putting large sums of money. Mm-hmm. We don't have a liquid market. And one thing that would have to change as well is there's a potential problem with waiver rules about confidential information. If an investor sees something which they'd like to look at before they make an investment, it's possible that the person who shows it to them, the client, has now waived privilege, and that's a risk that a lot of people don't want to take.
So lots of ethical concerns
exactly would have to be cleared up. Okay. Yes.
So what do you think would be the first step, Tony, to move things forward to allow non-lawyer investment in litigation in the U.S.?
I think the thing I just mentioned, I think clarity on the question about waiver of privileged information, that we need to have clarity on.
And how would that start? How
Well,
would that
I actually
process
think
begin?
the Bar Association would have to look at that because it
Okay.
might have to revise its own rules and the model rules.
So do you think maybe carving out some kind of exception?
Absolutely. Yeah, I think there should be a special exception. Right now, you know, we could imagine that there should be a joint interest exception, which you might have, for example, when third-party investors in a merger have access to confidential documents. But we don't have anything like that in these kinds of cases. We might want to create something like that.
Do you think that might, you know, sort of open Pandora's box, and do you think we would get a lot of pushback from the bar in that regard?
I don't think you're going to get pushback from the bar necessarily because of the monkeying around with the ethics rules or the privilege rules, although there are purists out there who don't want to touch it. But one thing that is clear is that you're going to get pushback from parts of civil society that are worried about this increasing the amount of litigation overall in society. I mean, last fall, the American Chamber of Commerce held an event where they explicitly came out against any opening up of third-party investment in the United States, making it clear that they see that as a bad thing for their constituency. And so you'll get pushback from that side of the political spectrum.
Well, it'll be interesting to see a year from now where we are if any significant changes have been made. Tony, thank you. There's certainly consensus here at the conference that your work was extremely valuable, so thanks for all your hard work.
Thank you. I enjoyed it.
Thank you.